first of all wish to confirm that His Excellency the President, through the notice issued by the Clerk to Parliament, has returned the appropriation bill for due consideration by Parliament of the Republic of Uganda. A question is posed whether this is disrespecting Parliament. I would say no. In our Constitution, under Article 91, this situation was envisaged by the constitutional framers, that at one point there could be an area where there is dissent between Parliament and the executive. And when that occurs, the constitutional framers made a provision under Article 91 to facilitate the process. So what is happening is a constitutional process, is a constitutional requirement, is a constitutional provision that is anchored in our national constitution under Article 91. And the constitution even prescribes what should happen. In this case, we are reliably informed that His Excellency the President has returned the bill with comments or in writing, and we shall wait until Tuesday at 10 to receive the comments contained therein. So there is nothing like disrespecting Parliament. This is just checks and balances between the executive and the Parliament. In terms of checks and balances in the budgeting process, the budgeting process of the Republic of Uganda is a statutory process provided for under the Public Finance Management Act, and we normally refer to it as the budget cycle. In a nutshell, budget proposals are presented before Parliament by the executive, and the role of Parliament is to approve as required by the law. So the checks and balances are contained in the budget cycle. You hear about the ministerial policy statement, the budget framework paper, committees meeting and inviting ministers with the different entities until the budget is approved. And this due process takes the whole year. In fact, the moment the budget for a financial year is approved and we start implementing, the next budget cycle starts. And the checks and balances are normally between the executive and Parliament. But this time round, the President indicated while addressing the nation at Kololo during the State of the Nation's address, while he was opening the first session, that for the first time, the three organs of government or of the state were able to meet through their respective leadership. And the budget that was presented to a tune of 72 trillion, what was agreed between the head of the executive, who is the President, the head of Parliament, who is the Speaker, and the head of the judiciary, who is the Chief Justice. This one came from the appointing authority, implying in terms of checks and balances, all was done within the law or formally and informally, because this meeting is not something which is stated in the law. Why didn't you oversee this incident? First of all, the due processes of the budget is handled in committees. The role of the government chief whip is to designate members. Major works of Parliament are handled in committees and they report on the floor. It may be easy, it may be difficult. That is why the due process of budgeting is a subject of checks and balances. We have the proposal coming, we have the approval being done, but once the approval process is done, the Clerk to Parliament extracts that particular record and now sends it back to the President for assent. Now, before assenting, there is also due diligence that is done to check whether what was proposed is what was approved. So in a nutshell, this is collective responsibility. It is not individual responsibility. We are collectively in charge of the budget, that is normally subjected to checks and balances between the two organs of government. House recall, why is HE the president? I believe that in the letter signed by the clerk recalling Parliament from recess, the details of the letter is not communicated. I believe that Parliament will be able to get what are the areas or what are the issues or what are the concerns being raised by His Excellency the President, because if he chooses to return the bill in writing, that means that particular concern raised or concerns raised by the President will be read on the floor, such that the entire Parliament that did the approval should understand that His Excellency the President is returning this particular bill to Parliament, and his concerns to be addressed by Parliament are A, B, C, D. So we wait until Tuesday at 10, when the presiding officer will officially notify Parliament of the reasons advanced by His Excellency the President for returning the appropriation bill for consideration by Parliament. Any other questions still remain? Affect the next financial year. I am reliably informed that Parliament received a notification from the President last evening, and by this morning a decision was already taken for Parliament to be recalled next week on Tuesday, implying the leadership of Parliament is alive to the fact that the moment we delay this process, we shall end up paralyzing the supplies of money for Q1 for the next financial year. That is the reason why, in my humble opinion, the Right Honorable Speaker decided with the clerk to convene Parliament at the earliest opportunity, such that whatever is requested for in the letter of the President can be able to be addressed maybe at the start of the next financial year, such that we don't end up paralyzing or frustrating the release of monies to government ministries, departments, and agencies. So in my humble opinion, this may not. This can be handled within 1 or 2 days. We shall be done. Then the bill will be returned to the President for assent. Is this related to what happened in Kenya? Yes, no. Ours is budget related. Ours is a bill, because at the end of the day, the budget proposal goes through a bill, and the moment the finality is a bill, the bill has to be assented to, just like a law, to give the Ministry of Finance the powers and the mandate to release the money. What happened in Kenya is consideration of the tax-related bills. We have already considered the tax-related bills and passed them. What we are talking about is the appropriation bill. The appropriation bill is the budget of the next financial year. Tax-related bills were handled and passed. I believe they have even been assented to. So these are two distinctions. Ours is budget. The one in Kenya is tax-related. Isn't Parliament going against the Public Finance Management Act? Is no. The fundamental question is, between the Constitution and the Public Finance Management Act, which one is supreme? The Constitution is supreme. And if there is any disagreement within any provision in any act and that of the Constitution, the one of the Constitution prevails. In this case, we are talking about the appropriation bill, much as it is the budget. But the constitutional framework thought it wise that to administer the doctrine of checks and balances, the budget must be transformed into a bill. Now, the bill, when passed by Parliament, is assented to by the President. But that is still the budget for the country. So it is like a law. So finance will have the legal mandate to release monies based on what has been approved by Parliament and assented to by the President. Now, in terms of going against Public Finance Management Act, in this case, it is Article 91 of the Constitution now prevailing over all provisions of the Public Finance Management Act, because this is an appropriation bill. That is provided for under Article 91, how a bill is returned to Parliament by the President. On MPs arrested under budget and cooperatives, as NRM Parliamentary Caucus considered a meeting to discuss, I want to answer this together with as NRM had a meeting to handle this. First of all, we must be alive to the fact that the issue of cooperatives was unearthed by a parliamentary committee chaired by a member of the National Resistance Movement. This is the Committee on Trade, Tourism and Industries, chaired by a member designated by NRM, deputized by NRM. Majority of the members are NRM. That must be understood. Secondly, the issue of cooperatives and all the monies involved therein were resources not appropriated by the 11th Parliament. These were resources appropriated by 10th and 9th Parliament, to state the facts right. So that means what the 11th Parliament did was to do an investigation, and that investigation was done by a parliamentary committee. For those who followed Parliament, you are aware when this report came, the Right Honorable Speaker that was presiding over on that day guided that this report should be entirely shared with the organs of government that are mandated to do further investigations, because the report and the content therein in terms of the finding had some criminality. So as Parliament, this was now outside our mandate. I believe that the report was shared by CID, the report was shared by the Inspectorate of Government, the report was shared by the State House Anti-Corruption Unit. That is why you are now seeing the results we are seeing. Now, NRM does not need to meet. NRM can take action even when it has not met. For instance, you are aware, March's majority of the members arrested are members of NRM. Majority of them were members of the Budget Committee. Honorable Mudimi was the Vice Chair of Budget Committee. You are all aware that last year but one, he was relieved of the Deputy Chair position in the Budget Committee. Honorable Namuju was a member of the Budget Committee. You are aware that when we were designating members to the standing committees last year but one, she was relieved of her membership in the Budget Committee. Honorable Akamba was a member of the Budget Committee. You are aware that when we were designating members into the standing committees, we relieved him of his membership in the Budget Committee. So whether caucus has sat or caucus has not sat, there are demonstrative actions that are taken in consultation with the leadership of the party. And basing on the evidence and proof I have provided in terms of relieving these members from their membership and leadership in or on the Budget Committee, you can be sure that the NRM could have not met as a caucus, but action was taken administratively in consultation with the top leadership. Now, where a matter is in court, the hands of NRM, even being a party in power, is tied by the law. We cannot meet at the moment to discuss a subject matter that is already before court. We know that there is presumption of innocence. They were arrested, they were detained, they were formally charged and remanded. There is already a case in court. Now, the National Resistance Movement cannot meet to discuss a case that is in court. That is against the doctrine of separation of powers. That is against the doctrine of constitutionalism. So for now, we took action, not within caucus, but administratively, while the leaders of the NRM were consulting. On the issues that are in court, we may not meet over them. We respect the rule of law, we respect the will of the people, we respect the judiciary, we respect the doctrine of constitutionalism. Do we term the return as part of the budget process? is returned is the budget for the next financial year. Is it still part of the budget process? The answer now is no. No, because the budget goes through metamorphosis, political metamorphosis. From the proposal turns into a bill. What we are now handling is the appropriation bill. But to a layman, the appropriation bill is the budget for the next financial year. So what we are now handling does not fall within the budget process of last financial year. We are now handling the appropriation bill, which upon assent by His Excellency the President translates into the Appropriation Act. At the end of the day, Finance will now be acting on the Appropriation Act to release money. Any other? Yes. You have seen this before. You are seeing it now. You are yet to see more. You have seen before how the party has been biting. You have seen how the party has been biting again in the recent past. You are yet to see more. So an emphatic yes. And if you need cases where the NRM government has sent so many people into Luzira on corruption-related allegations or charges, I think the list is there. The list is there. The DPP can provide, the Anti-Corruption Court can provide, the IGG can provide. There is a long list. Mamas on trying to avoid caucus. Generally, when we meet as caucus, we meet and discuss the subject matter. And in the recent past, every caucus meeting that has been held, I have always briefed the media of the outcome. And I have not at any one moment briefed the media that when we met, members were raising personal issues. We meet when we should. His Excellency the President has been clear that if the NRM chooses to be quiet, it is deliberate. If the NRM chooses to talk, it is also deliberate. If the NRM chooses to meet, it is deliberate. If the NRM chooses not to meet, it is also deliberate. But that does not mean the NRM is not working. The NRM is a revolutionary force, is a mission-led organization. In the words of the President, the NRM watches over Uganda 24/7, and the NRM is working 24/7. Don't wait for the organs of the NRM to sit for you to affirm that the NRM is working. The NRM works covertly and the NRM works overtly. So in a nutshell, we are present and we are working, and there is nothing we are avoiding. Even in our silence, we are working. Even when we talk, we are working. The other question on is already deferred. I think these offices are available. How do I feel? First of all, in principle, on the fight against corruption, we are all at one. Where we disagree is the modus operandi. The NRM is a political organization guided by a constitution and the rules of procedure for members who are members of parliament subscribing to the NRM Parliamentary Caucus. Our point of departure is when the NRM is faced with a challenge. Where do you run first? Even the Bible says, seek first the kingdom of God, and the rest shall be added unto you. And for us in the NRM, we are saying, when you are faced with any challenge as a member of NRM in parliament under the NRM Parliamentary Caucus, exhaust first the internal conflict resolution, the internal due processes provided for in writing by the NRM Parliamentary Caucus rules of procedure. That is where we fault our colleagues. And that explains the reason why I would say in clear terms that they have spent 6-7 weeks looking for 177 signatures in a population sample of 500 plus. Now just imagine there was limitation in the collection of signatures under that rule, probably 14 days or 2 weeks or 21 days, would you still state that that particular motion would still be alive now? It would be dead on arrival. So what I am stating is, we appeal to members of the NRM to respect the internal due processes of their party. If you have a challenge, first invoke. Because even when the chairman of NRM Parliamentary Caucus is not summoning a meeting, in the rules of procedure, the members of NRM are under obligation to request for that meeting in writing, signed by 1/3. And our rules are clear that the moment you receive a request signed by 1/3, you have 7 days within which to call a meeting of caucus. Did this happen? The answer is an emphatic no. So that is where we disagree. That you must respect your political nuclear family before going to your political extended family. Even in courts of law, you will not run with a case straight to the High Court. The High Court may receive a case as an appeal. But where do you run first? It may be a Chief Magistrate Court or a Grade 1 court. That is what we are saying. On the fight against corruption, we agree. In terms of how do you do it, is where we disagree. So in a nutshell, we are telling our members, you should have run to your nuclear political family first under the rules of procedure. And we have had cases. For those who have been around, you know these cases, where NRM takes a decision and even the members can be required to take action before the whole parliament descends on them. That is where we disagree. So the way I'm feeling, this is how I'm feeling. That the rules of procedure of NRM were flouted by the members of the NRM Parliamentary Caucus. And that should have been their first point of instance. The Obua, I know, we are helping the opposition. I want to say no. Just like one of you stated, in everything that we do, we are subjected to checks and balances. In designating the leadership and membership of committees where NRM is supposed to do it, normally we bring it on the floor, and there is no record that Parliament has ever rejected. In designating the leadership of committees and membership, those that are led by the opposition, there is no record to indicate that at the point of designating any member of Parliament into the leadership of committees chaired by the opposition, that particular designation is rejected. Now, what we are talking about is the withdrawal. Designation versus withdrawal. What we are talking about is the withdrawal. Now, if a party intends to withdraw the leadership that they designated, the due processes are provided for under our rules of procedure of Parliament of Uganda. That particular proposal to withdraw that leader or those leaders must be done with the approval of the whole Parliament. And that is now checks and balances. In doing that, we are not saying we are frustrating. Probably the whole Parliament has endorsed the leadership of Honorable Obua and Honorable Bagala. So it is only at withdrawal where you subject your nominees that were earlier on approved. Remember, when you designated them into the leadership, you designated them with the approval of Parliament. At the point of withdrawal, you also withdraw with the approval of Parliament. And in the approval, Parliament, in my humble opinion, has the latitude of saying yes or no. In this case, Parliament made the choice to say, we are still comfortable with these leaders you designated, and Parliament said no. So in doing that, we are not frustrating. Any member of Parliament shares the same privileges like any other member, be it in opposition or in government. We are the same. So when you are withdrawing, you must come with very, very strong justification to convince Parliament. Honorable Obua, you people know, has been a presidential candidate in this country. Now, for you to withdraw him from a leadership of a committee, from a leadership of a committee. Someone who presented his credential all over the country to be a president of Uganda. I think you must have strong justification. Is any of you doubting the capacity and the competence of Honorable Obua Bwanika, much as he's a member of the opposition, in terms of performing as chairperson of a committee?
No. Some of us, no.
Yeah. And the doubt, yeah, you are entitled. Now we are here. The rest are quiet, you alone. If there was voting, the ayes would have it. Against one nay. We can stop here. I think we... And constitutionalism. And I wish to appeal to members of the NRM in Parliament that for cases that are already in court, that are active in court, it would be imperative, it would be courteous, it would be reasonable of us to avoid making comments on them. Because under our justice system, all our members who are formally charged in court are presumed innocent until they are proved guilty or until they plead guilty. So I wish to appeal to all my comrades, members of the NRM Parliamentary Caucus, that even under the mainstream rules of procedure of Parliament, we are not allowed to make comments on any matter in court. So let us allow the due processes of our justice system to be invoked by the judicial officers on our colleagues who are currently before them. Hey, hotspot. So today the number is overwhelming. Let me see what God has.